Today marks 1 year since the Supreme Court upended nearly 50 years of precedent and eliminated the federal constitutional right to abortion.
The U.S. Supreme Court has again weakened the authority of the Environmental Protection Agency. As William Brangham reports, today's ruling limits the agency's power to curb water pollution.
We're back now with breaking news out of the Supreme Court. New rulings, including one against the Navajo Nation on their effort to get the federal government to address the tribe's desperate need for access to clean water.
Today, the U.S. Supreme Court ruled in favor of a Colorado man who argued his conviction in a stalking case violated his First Amendment rights.
The U.S. Supreme Court today dealt a major blow to affirmative action in higher education, striking down race-conscious admissions programs at Harvard University and the University of North Carolina.
Out of the Supreme Court, the court just ruled that the Biden administration's student loan forgiveness plan is unconstitutional.
This morning, the Supreme Court handed down a major decision rooted in First Amendment rights, but opponents say it violates the Civil Rights Act.
Each year, on the first Monday in October, the Supreme Court of the United States picks around 100 to 150 out of the thousands of cases that they are asked to review. Then the parties of the selected cases file briefs to the court. Oral arguments are typically heard between October through April. The Supreme Court justices meet twice a week for conferences to discuss the cases. Once a decision is made, justices are assigned to write the opinions, and then the opinions are made public. These opinions are issued throughout the year. However, they must issue decisions before the court recesses for the summer. That's why we see a lot of opinions typically being issued in late June and early July. This year, as well as last year, the Supreme Court has issued some very controversial opinions. This video is part of a three-part series on the Supreme Court. In part 1, I will talk about the recent decisions. Part 2, I will discuss how the Supreme Court got so conservative. In part 3, I will talk about the ethics of the Supreme Court, or lack thereof, and what can be done to improve the situation. The current makeup of the Supreme Court is 6 justices that were appointed by Republican presidents and 3 justices that were appointed by Democratic presidents. Therefore, we have a supermajority of conservative justices issuing very conservative decisions. On June 30th of this year, the court issued the opinions on 2 related cases, Department of Education versus Brown and Biden versus Nebraska, both related to President Joe Biden's student debt relief plan. Last year, Biden announced that he would use executive action to forgive $10,000 in student loans for borrowers earning less than $125,000 a year, or $250,000 for married couples, and forgive $20,000 in student loans to Pell Grant recipients. This plan would have helped roughly 1 in 8 Americans. The Supreme Court ruled that the Department of Education does not have the power to enact a plan to erase billions of dollars in federal student loan debt. First, we have an issue of standing, whether the plaintiffs could show that they were directly harmed by this action. In one of the 2 cases, the justices unanimously agreed that the 2 borrowers in that case did not have legal standing to sue. However, in the second case, the conservative justices ruled that the 6 states and Mohila, a major student loan servicing company, did have standing. Second, the majority opinion states that the executive branch does not have the power to make this action, and that this action has to be done by Congress. However, that goes completely contrary to how the laws were actually written. The Biden administration used the HEROES Act as the basis for his executive authority to forgive loans. That gave the U.S. Secretary of Education broad authority to waive or modify any statutory or regulatory provision applicable to student financial assistance programs under Title IV of the Higher Education Act of 1965 to ensure that the affected individuals are not placed in a worse position financially in relation to that financial assistance. In the dissenting opinion, it was stated that the conservative justices ruled not on standing or how the laws were actually written, but only disagreed with the debt plan politically. Also on June 30th, the court issued its opinion on 303 Creative LLC versus Elenis. In this case, a Colorado web designer, Lori Smith, was starting a business to make web pages for weddings. She said that she feared that she might someday be forced to prepare a page for a gay wedding, implying that it would be against her Christian faith. So she sued. Let's stop for a moment and take a look at that. A web designer did not like that Colorado had a state law that gave LGBTQ people equal rights to public accommodations. And that's it. In fact, this designer was never asked to actually make a web page for a gay wedding. It was just the very idea that she might. So she sued the Colorado Civil Rights Division, and the Supreme Court, conservative majority, agreed that her First Amendment freedom of speech and freedom of religion gave her a legal right to discriminate against LGBTQ people. This is a truly bad decision. First, Lori Smith did not show that this law actually caused her harm, therefore did not actually have standing to bring this case to court. Supreme Court cases are supposed to be right, meaning that the dispute is real and current, not hypothetical or speculative. Second, the websites are the client's speech, not the web designers. Speaking as a former graphic designer, I know that I've done a lot of graphic design, and it wasn't my speech, it was the client's. Web designers never provide the content of a site, just the layout. This is like going to CopyMax and having the store refuse to make Xerox copies of a politician's speech because they didn't agree with it. It's not the speech of the store by making copies. And finally, this creates a slippery slope situation here. What keeps people from refusing services to other groups? Like a web designer refusing to make a web page for an interracial marriage, or a Jewish wedding, or Muslim wedding. This decision paves the way to legalize discrimination. On June 29th, the court issued the opinions on two related cases: Students for Fair Admissions versus Harvard, and Students for Fair Admissions versus University of North Carolina, both challenging race-conscious admission policies at colleges and universities that are known as affirmative actions. I want to take a moment and stop and remind people why we have affirmative actions in the first place. While we've seen considerable progress in this country in regards to institutionalized racism, the effects of these practices can still be seen today. Since the European colonization of America started around 1493, white Europeans were allowed to own property and gain wealth and power. On the other hand, from 1528 to 1865, blacks in America were not allowed to own property. They were property. After the 13th Amendment freed the slaves in 1865, there were some improvements when it came to the treatment of black people. However, it didn't take long before Jim Crow laws and segregation came around. In 1896, the Supreme Court ruled in Plessy versus Ferguson, and that legalized discrimination and maintained a stratification of race. Blacks experienced employment discrimination and were limited to low-paying jobs. Redlining was a discriminatory practice that segregated neighborhoods, limited blacks and minorities to certain areas, or limiting them to rentals. Most colleges and universities banned the admission of black people. The impact was white families could continue to accumulate wealth through education, income, and property ownership, while black families were still subjected to separate but not equal black colleges and universities, low-income jobs, and renting in ghettos. The Civil Rights Act of 1964 prohibited discrimination on the basis of race, color, religion, sex, or national origin. Finally, black families could gain the American dream through education, employment, and property ownership. However, the effects of racial discrimination are still around, but are less visible. I really cannot overstate the effect of a 471-year head start that white people have benefited from slavery and discrimination. White people today may not actively discriminate or hold prejudicial beliefs, but still benefit from white privilege. Today, we see racial disparities with public school districts with the most Black, Latino, and Native students receive substantially less funding, as much as $2,700 per student, less than districts in a white neighborhood. Even today, Black Americans have lower high school graduation rates than whites, and the average income of Black families are around $24,000 less per year than the average of white families. Affirmative action are programs that assist historically marginalized populations. It needs to be said that affirmative action is not just for Black people, but also helps women, Hispanic, Asian, and Native Americans get employment and college admissions. Furthermore, students of color are more underrepresented at select universities today than they were 35 years ago. The need for affirmative action has not gone away. Diversity on college campuses enhances the educational experiences of students of all backgrounds. The Supreme Court ruled that the Equal Protections Clause of the 14th Amendment applies without regard to any difference of race, color, or nationality, and thus must be applied to every person. However, the effect of the court's decision to strike down affirmative action is that it leads to a decline in racial diversity at colleges and universities. That has been the case in places like California, Michigan, or Florida, where race-conscious admissions were banned. It is also important to point out that there have been many studies to suggest that racial and social economic biases in the SAT. Justice Sotomayor wrote in the dissenting opinion that ignoring race will not equalize a society that is racially unequal. Or as Justice Jackson said, deeming race irrelevant in law does not make it so in life. Being colorblind is a form of racism in itself. What it does is uphold an unequal status quo and silences racial minorities. Ironically, Chief Justice John Roberts wrote in the majority opinion that colleges may still consider an applicant's discussion of how race affected their lives, like in college admission essays. Furthermore, the Supreme Court ruling allows affirmative action in military academies and police forces. By their own admission, there are reasons for these programs, but still ruled against the use of these programs in colleges and universities. Can't they see the hypocrisy in this? Now, if you really want to improve diversity and racial equality in colleges, we need to eliminate legacy admissions. These programs give a preference to children or grandchildren of former graduates. Applicants with legacy are 5 times more likely to get admitted than those without. The problem with legacy programs is that they favor privileged families, and it was just 60 years ago when that only included white students. Legacy programs are much more racist and against the 14th Amendment than affirmative action programs. Other Supreme Court rulings this year include Counterman versus Colorado, where the court overturned a stalking conviction and proposed new standards of what speech is protected and what speech is a threat. This is bad because it really makes it easier for the stalkers. In Arizona versus Navajo Nation, the courts ruled against an 1868 peace treaty. At stake was a long-running dispute over the obligations of the federal government to supply water to Native Americans, and the Navajo Nation's request for a federal assessment of its water needs from the Colorado River. The court ruled against the Navajo Nation, and once again, the federal government is breaking its promises to Native Americans. In Sackett versus the Environmental Protection Agency, the court narrowed the scope of the Clean Water Act, and now more than half of the nation's wetlands no longer have federal protection. This is bad because most laws are intentionally written to have a certain amount of vagueness to allow the federal agencies, with the experts and the scientists, to decide how to enforce the law. Basically, now the Supreme Court, who are not experts in the field, is taking that discretion away from the agencies. So this will have repercussions beyond the EPA, the Clean Water Act, and the environment, but to every federal agency. In addition, last year's Supreme Court overturned Roe v. Wade and allowed states to ban abortions. They curbed the EPA's power to protect the environment. They ruled against treaties with the Native American people in Oklahoma. They protected the right for teachers to pray in schools. And they struck down a New York law that restricts concealed carrying of guns. And they ruled that a Catholic adoption group does not have to consider same-sex foster parents. Multiple polls show that over 60% of voters disapprove of the Supreme Court decision to overturn Roe. And many legal experts agree that many of these decisions are not based on Constitution or the law, but are strongly decided based on the political makeup of a MAGA court. So, please look out for next week for the next video in this series, where I will talk about the events that led up to how this Supreme Court got so conservative. In the meantime, please help the algorithm by hitting like and subscribe, and please make a comment. I really would love to hear what you think. Also, please share this video on your social media or send a link to a friend whom you think you might like this. One more thing. I was trying to increase the production value of these videos, so I bought a digital camera online to help this not look like it was really poorly made, and I wanted an HD camera. Unfortunately, when I bought this, it won't work. I am a college student, and I don't have money. I'm an unemployed college student. So, if you want to help this channel and me being able to produce better quality videos, I would accept a donation. So, if you're feeling generous, look at the description below. And thank you very much, and see you in the next one.